Good afternoon and welcome to the Appellate Division, First Department. I will commence with the call of the calendar. Counsel, please pay attention for your cases. People v. Anonymous, submitted. MIC General versus Okapa. Counsel for Appellant.
Michael Confusion, Your Honors, for the appellant.
You've been granted 4-1. Respondent.
Good afternoon, Your Honor. Natasha Millman for Respondent, MIC General.
Good afternoon, Ms. Millman. You've been granted 4.
Thank you.
R. Stefan versus Yesenia R. is submitted. Nation Star Mortgage versus McKellan. Appellant.
Joseph Altman appearing for the appellant. Good afternoon, Your Honor.
Good afternoon. You've been granted 4-1.
Thank you.
Respondent.
Good afternoon, Your Honor. Charles Jeanfrau for Respondent, Nation Star Mortgage.
Mr. Jeanfrau, you've been granted 4 minutes as well.
Thank you, Your Honor.
Natixis Real Estate Capital Trust versus Natixis Real Estate Capital. Appellant.
Seiji.
Go ahead. I'm sorry.
Seiji Newman from Davis and Gilbert for Natixis.
You've been granted 6-2. Respondent for computer share.
Good afternoon, Your Honor. Kathleen Sullivan from Quinn Emanuel for computer share.
Good afternoon, Ms. Sullivan. You've been granted 4 minutes.
Thank you, Your Honor.
Appellant respondent Wells Fargo. I understand there's a pro hoc vici application.
Yes, good morning. Good afternoon, Your Honors. Howard Sidman for respondent appellant to Wells Fargo Bank, seeking to and respectfully requesting that Andrew Stanton from the Commonwealth of Pennsylvania be allowed to argue this appeal on behalf of Wells Fargo Bank.
That application is granted. Mr. Stanton, welcome. You've been granted 4 minutes, and I just realized you are also a appellant, so I will give you an additional 2 minutes as rebuttal, okay?
Thank you, Your Honor.
You're welcome. People v. Marty Balo, appellant. Appellant for People v. Balo. Mr. Blakemore. Okay. Respondent, are you there?
Yes, Your Honor. Nathan Scher for the people.
I believe the appellant's counsel was present during the call of the calendar. Am I correct?
Yes, Your Honor.
Okay. I will try in normal order.
Pardon me, Your Honor. This is Patrick Blakemore. I was having an audio issue from David Cordwell on behalf of the appellant. Apologies.
Not a problem. You've been granted 6-2, and Mr. Shee, you've been granted 6.
Thank you.
You're welcome. Crawford versus 14 East 11th Street. And as I've indicated before the call of the calendar, this case will be heard first as we have a vouching judge, Judge Scarpula. Judge Gonzalez has recused herself. Appellant Crawford, Mr. Isaac.
Yes, Your Honor, I'm here.
Good afternoon. You've been granted 4-1.
Thank you, Your Honor.
Appellant Everest Scaffolding.
Hi, Your Honor.
Good afternoon, Ms. Glenn.
Yes, that's correct.
Okay, you've been granted 4-1 as well.
Thank
Respondent Hilux Construction.
Good afternoon, Your Honor. Jeff Ford from Perry Van Etten.
Good afternoon, Mr. Ford. You've been granted 3 minutes. And Respondent 14 East 11th Street.
Good afternoon, Your Honor. This is Stephen Ingrassi from Cuomo LLC.
Good afternoon. You've been granted 3 minutes.
Thank you.
Harris versus Structure Tech New York. Appellant.
Noel Tripp from Jackson Lewis. Good afternoon, Your Honor.
You've been granted 4-1.
Thank you, Your Honor.
Respondent Harris.
Jack Newhouse from Virginia Nambinder. Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank you.
2123 Avenue B versus Avenue B SM TIC 1 is submitted. People v. Yang submitted. Stevens versus RX Medical submitted. Cohen versus Cohen submitted. CRG Financial versus Amloyd Corporation respondent.
Your Honor, Matthew Bondi, Montgomery, McCracken, Walker, and Rhodes for the respondent Amloyd Corporation, and I'd like to introduce you to Jason Torf from Chicago, and I respectfully request that he be permitted to argue the appeal.
That permission is granted, Mr. Torf. You are granted 5 minutes, and Mr. Eisenberg, forgive me, I should have called your name first. Appellant, and you have been granted 5 and 2. Are you there? Mr. Eisenberg?
Yes, Your Honor, can you hear me?
Yes, now I can. Thank you. 5 and 2.
Thank you, Your Honor.
You're welcome. JCB Associates versus 54 Enterprises submitted. Valbuena versus 650 Madison. Appellant.
Kevin Ryan for the appellant, Your Honor.
You've been granted 4 and 1. Good afternoon.
Good afternoon.
Respondent American Construction.
Good afternoon, Your Honor. Gail Richard on behalf of Americon.
Good afternoon, Ms. Richard, and you've been granted 4 minutes as well. Garner versus New York Department of Health.
No, yes, still here for Micah Garner. Joseph Mitchell here for Micah Garner. Can you hear me?
We just lost video with Judge Mansonet Daniels, so hold up a minute. Let me call her a second.
Can you hear me?
Yes.
Thank you. My apologies. I got knocked out of the system. It happens to us all, as you see. Okay, Garner versus NYDHCR. Appellant, Mr. Mitchell.
Yes, Joseph Mitchell here for Micah Garner.
Good afternoon. You've been granted 4 and 1. Respondent NYDHCR.
Sandra Joseph for DHCR.
And respondent PWV Acquisition.
For respondent PWV Acquisition, excuse me, Wayne Desimone, Your Honor, Cullen and Associates.
Thank you so much. You've been granted 3 minutes, both respondents.
Thank you.
Each 3 minutes, yes?
I'm sorry? Each 3, yes.
Thank you.
Yes. That would be a really short argument. Try Masa Restaurant versus Global Coverage. I understand it's a Pro Hoc Vici application for appellant.
Correct, Your Honor. My name is Christopher Johnson from McCool Smith, and I request that my colleague Joel Tholender of Texas be permitted to present argument today.
That application is granted. Welcome, Mr. Tholender, and you've been granted 4 minutes. Respondent.
Howard Kronberg for the respondent, Your Honor.
Good afternoon. You've been granted 2 minutes.
Thank you.
Wallace versus TriMed Home Care. Submitted. Securitized Asset versus Canadian Imperial. Submitted. Called out of turn. First case, Crawford versus 14 East 11th Street. And Judge Gonzalez will absent herself from the call of this case. Counsel?
Yes.
Mr. Isaac, you may proceed. You have 4 minutes.
Thank you, Your Honor. Brian Isaac, I represent the plaintiff appellant cross respondent. Given the shortness of time, I'd like to focus on the 240 sub 1 claim, if I can, on my direct appeal. Obviously, this is a summary judgment motion, and the evidence has to be construed in the light least favorable to me with respect to summary judgment. So I'm going to discount my client's version of the accident. Let's talk about what the defendant says. Defendant's version of the accident is the plaintiff is climbing down, not up. It's using the cross braces on the photos that you can see at 365 to 369 of the record. Inadvertently contacts the wood that serves as a guardrail. The wood falls down. He falls down to the lowest scaffold and is injured. No dispute that there are no other safety devices provided at all, such as harnesses or lanyards, things of that type. And there's no dispute based on the testimony from all of the parties that there was.
Well, excuse me, Mr. Isaacs, this is Judge Gish. There were stairs on the scaffold for getting up and down it, weren't there?
According to the defendants, there was a stairway that could be used from the 2-plank scaffold that the plaintiff was using. I would point out to you, Judge Gish, that if you look at page 365 of the record, which is the color photograph, I'm sorry, not 365, 366 of the record, which is Exhibit 4 that everyone's talking about. It's a little hard for me to see. My eyes aren't so great as I'm getting older. I don't see a stairway there at all, but let's assume there is a stairway there. My position is it doesn't matter because the plaintiff has to have been told specifically by someone not to use that area. And I would point out something that's just simple common sense. These are construction workers. They're working outside. There would be no reason that I can think of for a construction worker to scale cross braces and then kind of climb through to an upper or lower level scaffold if there was a stairway right there. And what we're specifically relying on, Justice Gish, is your decisions in Jurisitano against Brookfield Properties, it's 157 AD3 D622, and Anderson against MSG Holdings, which is at 146 AD3 D401, which we believe stand for the proposition that unless the plaintiff is told not to do something, the plaintiff's negligence cannot be used in defense of a 240 sub 1 claim. And I submit to the court that this case can be decided based on literally 5 pages of the record, 517 to 523. As you know from reading the briefs, Mr. Glasser testified extensively about what Mr. Brady, the project manager, said or didn't say, but Mr. Brady never testified. The testimony by Glasser about what Brady said is pure hearsay. It's an out-of-court statement sought to be introduced for the truth of the content, and it forms the fundamental basis of the defendant's defense. And if you look at 518 of the record, 518 line 16 to 519 line 24, it's very clear that what Mr. Glasser is saying is that workers, not one worker, but workers from Coffee, who is the plaintiff's employer, had scaled and descended from the scaffold by the means used by the plaintiff. And it says that he told them not to do it, but he never saw Mr. Crawford going from the workspace to the metal cross bracing. That's 519 lines 20 to 25. And then on 520, starting on line 2, all the way down to 521 line 25, there's testimony from Glasser about the fact that Mr. Brady would have told the plaintiff at safety meetings not to use this method. But I can't find anywhere in the record, and my adversaries, despite writing beautiful briefs, haven't cited to it, where there was testimony that Glasser knew that happened, that Glasser was present when that happened. And as you know from reading the briefs, the plaintiff specifically said he wasn't given any such instruction. He didn't attend any safety meetings. So this is not a case where there could not have been a defense. It was a case where the evidence did not make out a defense. And I would point.
Thank you. You'll have a minute on rebuttal.
Thank you so much, Your Honor.
Okay. Ms. Sklan?
Hi, Your Honor.
Hi.
Good afternoon. It's respectfully submitted that this court should reverse the trial court's order insofar as it failed to consider Everest cross motion on the merits, since it's our belief that no prejudice would result from its consideration, which no party contests, and it was
late, right?
Yeah. Yes, it was late. We believe we meet the good cause standard since the oppositions filed in response to plaintiff's timely motion contained concessions that the scaffold was proper and adequate and not defective in any way. And it wasn't until that time that we had a basis to move for summary judgment.
But what case stands for the proposition that you can wait, that waiting for another party's response is good cause to submit your own motion?
I don't have a case that stands for that position, but I also don't have one to the contrary.
Can we talk about the merits, though? Let's talk about, and just put it in the context of you are opposing summary judgment. What did you create an issue of fact?
We didn't oppose the plaintiff's motion for summary judgment. It was not made against Everest. It was made against Hillocks and 14 East on the 240 and 241-6 claims. But with respect to the merits, since it was established that Everest isn't an owner, contractor, or agent, we believe that the 241 and 241-6 claims, which were the subject of plaintiff's timely motion, should have been considered and dismissed. And on the labor law 200 and common law negligence, as well as our cross claims against Hillocks and 14 East, we believe that we established that we are entitled to summary judgment since they admit the scaffolding wasn't defective and no opposition was submitted on the merits to our argument with respect to the dismissal of the cross claims against Everest or for summary judgment on our contractual indemnification claims against Hillocks.
Thank you.
And based on all of that, we believe that if the merits were considered, it would streamline the issues, to be tried as against Everest, if any, at trial.
Thank you so much. You'll have a minute. Mr. Four, we'll hear you. 3 minutes.
Thank you, Your Honor. First, with respect to plaintiff's claims, it seems to me that part of the argument is that Mr. Crawford was not explicitly told not to climb down on cross bracing. Mind you, Mr. Crawford gave two separate versions of events in his deposition testimony, 2 separate sessions. However, Mr. Crawford admitted, and it's on page 239 of the record, that he knew you're not to use cross bracing as a ladder rung and that doing so is an OSA violation. So whether or not he was specifically told by Hilux or anyone not to do it, he knew it. The knowledge is there. So I submit that Hilux is not required to do it. Mr. Glazer from Hilux did testify that the subject of weekly safety meetings was that people were told not to climb down the cross bracing. Now, Plaintiff's counsel has made an argument that they never heard from Mr. Brady. Well, Mr. Brady was not employed by Hilux at the time the lawsuit was started, and they never pursued a deposition of Mr. Brady. Now, turning to Everest.
Well, that doesn't change. That doesn't change the hearsay problem, though, right?
No, that doesn't change the hearsay problem. But just
right, but you're allowed to use hearsay to oppose a summary judgment motion as long as it's corroborated, right? May not stand up at trial, but is it okay here? Is it otherwise corroborated?
Well, if you look at the testimony of Mr. Crawford, when he said, "Oh, I wasn't specifically told not to use it," he admitted that he went to safety meetings, and he also testified succinctly that I know I'm not supposed to climb down the cross bracing and use it as a ladder rung. This is a case where Mr. Crawford made a conscious decision, and this comes right into it comes right into the Cahill case, that he made the determination not to use the staircase to climb down the side of the scaffold. Now, with respect to the claim that there's no safety devices, this scaffold had netting around it. It was in compliance with 20 CFR 1926.457 because it had cross-bracing safety netting.
Thank you so much for your argument. You're out of time.
I didn't get to. Okay.
Mr. Ingracia, we have your papers, sir. Please don't worry. We read it all.
Thank you, Your Honor.
Mr. Ingracia,
Hi,
you have 3 minutes.
Good afternoon. As it please the court, my name is Stephen Ingracia on behalf of the respondent, 14th 11th Street. We're here in opposition to plaintiff's appeal. We believe that the Supreme Court originally got the decision right in denying plaintiff's motion for summary judgment, finding there were issues of fact, whether there was a violation of Labor Law 241 and whether the plaintiff was the sole proximate cause of the accident. As plaintiff hinted to, there were two different versions. There was plaintiff's side, and then there was Mr. Glazer's side, where Mr. Glazer testified that plaintiff told him that he was trying to climb down the cross bracings of the scaffolding, stepped on a back rail, and then caused himself to fall. At the Supreme Court level, plaintiff went to extreme lengths to discredit Mr. Glazer's testimony, but now on appeal, he flips and says even if you accept it, he wins because he wasn't personally told not to climb on the outside of a scaffold and because he wasn't provided with a harness. So just two things quickly. As for the harness, and plaintiff cites that regulation, 29 CFR 1926.451. That requires a harness only if there's not a guardrail. The use of the word "or" in the disjunctive means one or the other. As the Supreme Court determined, this scaffold equipped with safety netting, OASIA boards, OASIA planks, toe boards, and safety netting was a safety device. As such, a jury can reasonably conclude that this scaffold was a safety device with a guardrail system in place, and as such, plaintiff did not need a harness. As for the not personally told aspect of plaintiff's appeal, first, this ignores the argument that plaintiff is an experienced OASIA certified union member who should know to not climb on the outside of a scaffold and use the rungs to go up and down. Second, it ignores the testimony from Mr. Glazer that he attended meetings where the safe use of the scaffold was attended prior to plaintiff's fall, and the use of the scaffold was addressed because they had previously witnessed someone climbing up and down the rungs. Plaintiff in his brief cites the case Porobowski as saying that he needs to be told that there is an alternate way. However, that only arises when there's two accepted ways. Here, there was only one accepted way, the metal staircase. Climbing up and down the outside of a scaffold was never a second option. So as such, we believe that the Supreme Court got it right the first time, that there are issues of fact as the plaintiff's Labor 241 claim, and in the alternative, the plaintiff's own testimony. If he wants to accept Mr. Glazer's testimony, he mentions that he was either a sole proximate cause of a recalcitrant worker at the time of the accident. Thank you.
Thank you. Mr. Isaac, you have 1 minute. Mr. Isaac?
Can you hear me now?
Now we can hear you. Go ahead.
I'm going to speak quickly. My adversary says that on page 239 of the record, Mr. Crawford said that he knew it was inappropriate to climb down. I have the page up. It doesn't say that. One of my other adversaries said that Mr. Glazer said he attended safety records. The record doesn't say that either. 520 to 522 says exactly the opposite. The fact of the matter is that the difference between this and Cahill is that Cahill, it was understood and accepted that the plaintiff was told to use a certain harness and he didn't do it. Here, there was a break or a defect in the scaffold which caused the fall. We don't have that in Cahill anyway. And in fact, you have said, and the term of art that you've used is specifically instructed. You just held that in a case called Valdez against City, 2020 New York Active Lexus 7327. And in a case involving hearsay that was decided just before the start of the new year, Clark against Empire General Contracting, 2020 New York Active Lexus 7916. You made clear, as Justice Gish alluded to, that hearsay can defeat summary judgment, but it has to be corroborated and it can't be the only evidence, which is precisely what we have here. Thank you.
Thank you. Ms. Glenn, you have 1 minute.
Thank you, Your Honor. I'd just like to point out that both plaintiff's motion and Everest motion were adjourned on the consent of all parties, and each party was given the opportunity to and did submit opposition. And the only party who addressed even the merits of our arguments was plaintiff. And, therefore, the court does consider the motion on the merits. We believe that dismissal of all the cross claims and judgment on our claim for contractual indemnity is warranted.
Thank you so much.
Thank you.
Have a good day.
You too, Your Honor.
Thank you, Judge Scarpula.
Thank you.
Okay, we await Judge Gonzalez to rejoin us, and we will then call MIC General versus Okapa. Counsel, you should get ready.
I'm
Judge
here.
Gonzalez?
Yes, I'm back.
Wonderful. Okay. Counsel, you may proceed. You have 4 minutes.
Thank you for hearing the case, Your Honors. I rely on my brief. I'd like to point out just a couple of parts of the record that I think are critical in deciding the issue. We're asking that the court remand the case and reverse the summary judgment decision. You know, the plaintiff was the insurance company. They filed a declaratory judgment action, as the court knows, and they said that we're entitled to a declaration that we don't owe anything under the policy, under duty to indemnify or defend, because it was not an insured location. If you look at the summary judgment submission the insurance company submitted the plaintiff, they attached this kind of handwritten statement that one of the two insureds, Mrs. Okapa, submitted to an investigator before the lawsuit was filed in 2018, where she indicated that, you know, they had moved into their new home in July of 2016, which was about 2 months before the loss, the date of the loss, which was in September. And the insurance company said, well, based on that statement, we're entitled to summary judgment because therefore it's not an insured premises. My submission is there was a factual issue, at least, that should have prevented the court from granting judgment as a matter of law. And it's for a couple of reasons. One is there was an affidavit submitted in opposition to summary judgment below by Mr. Okapa, where he explained that's not true, that nobody was living there because they were separated. He and his wife had, the record shows they had some marital issues. They must have had some kind of horrible loss of their 3-year-old son. It looked like about 2012, so it looked kind of understandable without getting too deep into it. But they had some marital issues, and this was a 2-family home, the record shows, if you look at the deposition testimony. And the brother,
isn't there also, and wasn't it part of the plaintiff's prima facie case that it was a 1-family home and that had been rented to another family during the operative time?
Well, the plaintiff, you know, the plaintiff's submissions were kind of inconsistent on that front, to be honest with you, because in the actual affidavit that was submitted, let me get to that affidavit. The affidavit that was submitted in support of the summary judgment motion, actually, this is at the record at 55, Your Honor. Paragraph 10, this is the affidavit in support of the plaintiff's motion, says that the policy defines residence premises to mean the 2-family dwelling where the Okapas reside. And then so I would say, no, it was never said to be a 1-family home. And in fact, if you look at the actual policy, which is the record at 71, if you look at paragraph 8, it says residence premises also means a 2-family dwelling where you reside in at least one of the family units. So one, the policy language itself, and even the affidavit of the plaintiff, which was submitted in support of summary judgment, does not show that this was a 1-family home. And if you look at Mrs. Okapa's deposition testimony, you know, what's interesting is the timing of it.
Counsel, I'm going to give you 30 more seconds.
Okay. I would say this. The most important parts of the record are, look at the record at 181 to 183. Mrs. Okapa in there talks specifically about the separation that her husband had and that her husband moved back into the first floor unit of the 2-family home with his brother, Greg. Right there, you can see that there's a factual issue about whether this is an insured premises.
Thank you. You have 1 minute on rebuttal.
Thank you.
Respondent, Ms. Millman.
Thank you, Your Honor. Natasha Millman for MIC General. We submit the summary judgment was properly granted in this matter, that MIC General made out a prima facie case and was entitled to summary judgment. Policy language unambiguously requires residency at the premises as a condition to coverage. This is a single-family home. Everything that we submitted indicates that it is. The policy language does cover up to a 2-family home. This is a policy form language. This type of policy can be issued for a premises that's either 1 or 2 families. So it's
what do you have in the record that indicates that it's a 1-family home?
I believe the lease that we submitted indicates that it's a 1-family home, and the affidavit of Daniel Brownsy, who's our insurance adjuster. indicated that it's a one-family home. And it
Well,
was
how would he know that? How would he know that? Are there any
because
public
he's the
records
adjuster.
that you relied on?
He is the adjuster, Your Honor, and he is familiar with the whole process of the case. So he has the policy, he has the disclaimer letter.
The policy doesn't indicate whether it's a 1 or 2 family home. There's usually public records that would otherwise confirm that. Or you said the lease. What is that? The lease with the
tenant, Ms. Nguyen.
tenant plaintiff?
Yes.
And that says it's a
Tenant
one,
plaintiff in the
and it
underlying
says it's
matter.
one family residence?
Yes.
The whole demise premises, the whole building.
Correct. I'm not sure if the argument.
Where is it? What is it? For a quick reference, where is the page of the lease?
I'm not sure. I don't have the exact reference to the record at the ready at the moment, Your Honor. I apologize. I just know that that was attached as an exhibit to the affidavit of Daniel Brownsey. I could supply it later on. But the affidavit submitted in opposition to summary judgment by Mr. Okapa was just tailored to correct his wife's previous testimony, which a previous admission that she made. There was no affidavit submitted in opposition.
I don't see that being inconsistent. The fact that they moved to the new house in July does not necessarily mean that it is untrue that he moved back sometime after because of marital problems and before the accident.
Understood,
Those things aren't mutually exclusive.
Understood, Your Honor, except later in that deposition testimony, he couldn't say with any degree of certainty what the dates were. And in Mrs. Okapa's deposition testimony, she could not say with any degree of certainty.
Wasn't that an issue of credibility? I mean, why are we doing that on summary judgment? So it sounds like maybe you have a good claim that they weren't telling the truth.
And even taking his affidavit as true, Your Honor, he admits that he didn't have the intent to remain as is required under.
Where does he say that?
He stated he was there for 3 months and then he left again. So
that doesn't counsel. You are making leaps that are not consistent with the actual statements in the record. That's not what he said.
Your Honor. I apologize, Your Honor.
So, counsel, let me go at this from a different angle. So let's assume for the sake of argument that Mr. and Mrs. Okapa manufactured facts so that they could qualify for coverage. Does the fact that the tenant also joined in the fray by failing to acknowledge that, by saying that he was there, does that raise an issue of fact? If you recall, in the answer, she did not deny that he was not there.
I'm not sure I follow. I apologize.
The tenant,
Yes,
tenant who had the accident, didn't she also indicate that Mr. Okapa was living at the house?
No, I do not believe she said that. That was not on the summary judgment record. And counsel for Nguyen was present at the oral argument.
Thank you. Mr. Confucian, you have 1 minute on rebuttal.
I think the one thing I would say is I don't think that there was an opposition to summary judgment from the tenant, just addressing that last question from the court. But I do think if you look at the pleadings, I think that that Sylvia Nguyen, who's the tenant, denied that aspect of plaintiff's allegation that it was not that the Okapas were not there at the time. So I don't know if the pleading itself would create a summary judgment factual dispute, but that was the only statement from the tenant in that regard. I think the court understands the issues. I mean, our simple point is there was a factual dispute on a controlling policy provision. Even if you look at the record I cited before, 179 to 85 was Mrs. Okapa, and then look at 146 to 147 is Mr. Okapa. And in his deposition testimony, now not in great detail, but he did reference, we got separated and I moved out for a time. So all these things are not inconsistent. This isn't the self-serving or sham affidavit situation. that the plaintiff is saying isn't sufficient to create a issue of fact. And the policy itself, with regard to whether it was one or two families, again, the policy itself has
Thank
the
you.
record.
We're out of time.
Thank you
Thank
for
you
hearing
so
the
much.
case. Thank you.
Nation Star Mortgage versus McKellan. Mr. Altman, you have 4 minutes.
Yes, Your Honor. Thank you. I represent the defendant appellant in this foreclosure action. As the court, I'm sure, is aware, this is the second time this case is on appeal. Last time the matter was on appeal, the court had actually reversed the lower court decision and ordered that the matter be resolved by a traverse hearing. Instead of having the traverse hearing, the plaintiff respondent in this appeal decided it was a good idea to bring a 306B motion to extend their time to serve the summons and complaint. However, the time to do that was already expired. The time to make a proper motion, if there was such a time, would have been when the defendant brought their order to show cause to vacate their default.
Well, I don't think there's nothing in the CPLR that limits the time. The question is the interest of justice, right? What you're talking about is one of the factors that really counts, I think, heavily in your client's favor, which is that they were kicking around for a few years, knowing that your client was contesting service, and it would have been certainly more prudent for them to have brought the motion when they first knew that this was your client's claim, right?
Yeah, that's correct, Your Honor. The court below found there was no good cause. However, the court below, the error was
interest of justice.
The interest of justice, right? And there really isn't, because they caused their own problems. They waited 9.5 years to bring this motion. They took like 5.5 years just to move to get a default judgment. So nothing here was the cause of the defendants who really didn't know that this case was even filed, because for whatever reason, the bank decided to serve them not at the property where they live, but at some other address.
At her brother's address, apparently, right?
Right. Yeah, I mean,
and it's never been explained. Never had a traverse hearing.
Right, and that's why the court had ordered the traverse hearing. I mean, honestly, we had hoped that the court wouldn't, but unfortunately, the court did, and it's up to the bank now to make out a proper traverse that they served them properly. Their time to front that 306B motion, truthfully, has gone. They don't have, in the interest of justice, any statute of limitation defenses really was not due to the defendants delaying this case one bit. We did exactly what we were supposed to do, and the bank decided really to sit on their claims, and somebody back at the home office must have decided, hey, we don't want to have a traverse hearing because we're probably not going to win because we know it. We didn't serve them properly. Hence, let's see if we can get away with the 306B motion. And notably, Your Honor, they did not provide even an affidavit of merit in their 306B motion. They didn't have a verified complaint. They didn't have an affidavit of merit. They have no real proof.
Dispositionally, though, even if you win, there's still a right to a traverse hearing.
Right. I mean, truthfully, that's really what it's going to go back to, because this court ruled a little while ago that we have to have a traverse hearing. That's been stayed by this court's interim order. So just waiting to go back for the traverse hearing, which is really what the plaintiff wanted but doesn't really want.
Thank you. You have a minute in rebuttal.
Thank you, Your Honor.
Mr. Jean-Fro?
Good afternoon, Your Honor. I first want to raise just one issue. I don't know that this court in the previous trip to the First Department ordered a traverse hearing. The court reversed the prior dismissal of the case and talks about having a traverse hearing, but I don't see anything in that order that requires a traverse hearing.
Counsel, so are you suggesting? Yeah. We don't give advisory opinions.
I'm just saying
decision, that's what was expected.
I assume that is the case. But I think it's a misstatement to say it was required, and that
if you didn't have a traverse hearing,
in some way stopped us from moving for an extension of time. I think either of
We didn't
those.
address it one way or the other in the appeal.
Address it
It
one
wasn't
way or
an
the other.
issue.
Right,
You know, so
exactly.
the question really becomes, you know, in terms of entitling you to interest of justice, wasn't an abuse of discretion for the court below to not have considered that you were on notice that service was a potential problem in this case years before, and that you didn't do anything about it until 9 years later.
Well,
I mean, that's kind of, it's, you know, it's like you woke up one day.
Well, Your Honor, I think first I would say 9 years is a little bit too much.
How many years?
It was first raised in 2015 by a order to show cause. At that time, NationStar's predecessor.
So let's go with the first decision that was appealed. You certainly you knew by then, because the motion got granted. You knew by then that there might have been a problem. Why not from then? How many years from then?
The motion was granted.
You know what? I'm going to make this easy for you. How many years do you say you knew about this before it occurred to your client or you to make a motion in the interest of justice to be able to serve beyond the statute of limitations?
The first indication I think that they could have had was in October of 2015 when the order to show cause was first entered.
Bingo, I agree. And then when did you move? When did you ask for interest of justice permission?
After this case was remanded back to the
Just
trial.
give me a date.
It was May of 2019, I believe.
So 4 years.
Most of which time the case was on appeal to this court and had been dismissed. So they would.
But
I would
counsel,
submit that they would
even after the appellate division issued its decision, you still waited 5 more months.
That is a couple of months, and I think you can look through the cases and find some cases where more than 5 months passed. But that is a judgment call for the lower court to make. And I would argue that even if you concede, even if I were to concede that the lower court was correct in finding that 5 months was too long for NationStar to have waited, the court also found that the other 4 Leader versus Maroney factors that it was required to consider in doing its interest of justice analysis pointed towards.
Thank you, sir. Thank you. You are out of time. Mr. Altman, you have 1 minute on rebuttal.
Yes, Your Honor. I believe that the court has narrowed the issues very clearly, Your Honor. He has no reason for having waited any particular period of time here beyond when we originally brought this application in 2015. The court below error was when they calculated the time from when the court made their motion and called it 5 months, when it really was five years and maybe 6 months, Your Honor. So we ask that the court reverse this decision and order of Judge Gonzalez and remand it to the court in accordance with this first decision and order.
Thank you.
Thank you, Your Honor.
All right, I'm going to try to say the name of this case again. Natixis. I know I'm getting it wrong. Say it again.
Natixis.
Natixis. Okay, that's a little easier. Natixis versus Natixis Real Estate Capital and Wells Fargo. Okay, Mr. Newman, you may proceed. You have 6 minutes.
Thank you, Your Honors. Good afternoon. Seiji Newman from Davis & Gilbert for defendant and third-party plaintiff Natixis. Turning first to the borrowing statute, by this appeal, Natixis is simply seeking the opportunity to litigate for the first time whether this nearly $1 billion lawsuit is timely, pursuant to CPLR 202. Now, this court has explained, in fact, it did so in a prior appeal in this case with Justice Manzanet, you on the panel, that the law of the case doctrine bars a claim only when the particular issue that is being asserted has been actually litigated before a court in the case. Here, however, the borrowing statute has never been litigated, and so law of the case cannot bar the 202 defense. And separately, Natixis hasn't waived its right to assert 202. As the trial court itself stated, quote, Natixis was not required to allege a specific statute or even the correct applicable statute in its original answer in order to preserve its borrowing statute defense. And so it would certainly be an excessively severe result to deem this statute of limitations defense waived merely due to a pleading defect. And as such, and for the following reasons, Natixis should have a full and fair opportunity to litigate 202. First, the specific issue that was litigated in Natixis's prior motion to dismiss was whether plaintiff's claims were barred pursuant to
familiar. It was a 213. It was a 6-year statute of limitations. And that if you're going to apply the borrowing statute, and nobody really kind of goes into that much detail on this, we would be dealing with the California 4-year statute of limitations, which would bar the whole action, right?
That's exactly right.
It has pretty significant consequences here.
Absolutely.
So, you know, when you say, you know, that you didn't waive it, you went forward on one theory of the statute of limitation. Why weren't you required, when in the prior motion practice dealing with statute of limitation, to kind of lay your cards out about what statutes you were proceeding under?
Well, first, Your Honor,
why do you do a piecemeal?
Exactly.
Well, first, Your Honor, it's because the case law doesn't require parties to lay out all of their specific bases for the statute of limitations defense. In fact, as I just said,
maybe not in a pleading, but there was a motion practice. It was a dispositive motion. You got to kind of come forward with what you got, right?
Absolutely. However, at the time that the motion was made, and that was back in 2015, or excuse me, 2013, neither this court nor the Court of Appeals, first of all, had rendered its decisions in the Deutsche Bank matter, which was the first case to address the borrowing statute in the context of an RMBS case with a trustee involved. Separately, I'd also note that—
Well, why does that change, as my colleague has just said, the well-settled law that you have to come forward with all available arguments that you have in the first instance? You cannot piecemeal these requests and these applications.
You're correct, Your Honor. However, in this instance, the courts have held, not just in the context of a pleading, but that a party need not specify a specific statute of limitations in order to preserve that defense for later on. Again, the peculiar procedural aspect of this case also, it implicates the fact, and is an explanation for why the borrowing statute was not raised in the motion to dismiss. Deutsche Bank, the trustee here, again, is not the plaintiff in this case. ComputerShare is. ComputerShare is a stranger to the PSA, nor is even Wells Fargo, which commenced the case, still a plaintiff in this case. And so it would not have been appropriate on a motion to dismiss to address either the plaintiff residence rule or the multi-factor test, which would require numerous factual and legal issues to be resolved here.
I don't understand. Let me just step back a little bit. You know, they took us in a way, or they became like the plaintiffs because they were kind of successors in a way, or maybe not. I know that's still an open issue here. But they took in sort of a representative capacity that they brought the action. The borrowing statute is one of the oldest statutes on the books, all right? Everybody knows about the borrowing statute. So the argument, even though it was never applied possibly in an RMBS case, the concept of the plaintiff's residency or the transaction or where the action took place was certainly concepts that have been floating through the common law for years in terms of statute of limitations litigation. Correct?
Correct, Your Honor. Yeah, absolutely.
So why couldn't you be like an inventive lawyer, like the inventive lawyers in the earlier Barclays case, and just raise it timely? You know what? I mean,
Your Honor, if I may, again, in this context, it would not have been appropriate to raise it on a motion to dismiss. Deutsche Bank here, the California entity, Justice Manzanet, that you referred to, is not a plaintiff to this case. There are simply no allegations in the complaint at all as to the residents of Deutsche Bank or even to the residents of Wells Fargo, the securities administrator and master servicer here.
But that hasn't changed. That hasn't changed, and now you're raising it. I don't get it.
That's correct. We were raising it now because it requires a more full factual record to argue it properly, and it will be argued properly during summary judgment or at trial. Again, the four corners of the complaint simply don't have the requisite allegations to assert that this argument, and it is why it's been appropriate to not have raised it then and to raise it as an affirmative defense. And again, as this court has held, and the lower court,
you have 2 minutes on rebuttal. I've heard you say again twice. Okay. Mr. Stanton, I'll hear you. You have 4 minutes.
Your Honor, do you want to hear from Wells Fargo first, or would you like to hear from Computer Care first?
Since Mr. Stanton has been given 2 minutes in rebuttal, I figured I would hear him first.
Thank you, Your Honor.
Okay. Mr. Stanton.
Thank you, Your Honor. In this case, Andy Stanton on behalf of Wells Fargo, third-party defendant and respondent appellant. In this case, as it relates to Wells Fargo, Natixis has asserted completely novel claims wherein, as the sponsor of an RMBS transaction, Natixis seeks to pass off to Wells Fargo its own repurchase liability for representation and warranty breaches if it has that liability. And all 3 counts of Natixis's amended third-party complaint against Wells Fargo seek the same relief. Natixis seeks damages only to the extent that Natixis has any repurchase liability in the first party action. In that context, Your Honor, I'd like to make 3 points here. The first is that under the terms of this pooling and servicing agreement, Natixis clearly owes Wells Fargo, as master servicer, contractual indemnity for the claims that Natixis has asserted in count 2. In count 2 of Natixis's complaint, Natixis asserts that if it is liable for breaches of 2.03D in the PSA, then Wells Fargo owes Natixis for having exacerbated or made worse those repurchase damages that Natixis may owe. Section 9.12 of the pooling and servicing agreement contains an indemnity wherein Natixis agrees to indemnify Wells Fargo as master servicer and hold it harmless against any and all claims, losses, penalties, fines, forfeitures, related cost judgments, any other cost, liabilities, fees, and expenses that the master servicer may incur or sustain in connection with, arising out of, or related to a material breach of the unaffiliated seller's repurchase obligations under Section 2.03D. The unaffiliated seller is Natixis. It is very clear, based upon the words that the parties used, that liabilities as a result of Natixis's breach of 2.03D are allocated to Natixis. Arising out of, that phrase is a but-for causation standard. In the trial court opinion, the trial court found that because Natixis was alleging Wells Fargo was at fault, the indemnity provision couldn't apply. The law is clear that you can have multiple but-for causes, and the trial court did not give meaning to the remainder of the terms in connection with or related to, which imply even looser causation than but-for causation. So it's clear count 2 should have been dismissed, and the trial court's failure to dismiss it was error. For similar reasons, count 3 of Natixis's complaint was properly dismissed. Natixis sought contractual indemnity from Wells, but doesn't have it. There's a general provision. The specific provision allocating repurchase-related liabilities to Natixis prevails over that general provision.
So you just so that I understand, you're saying that the count 2, the way that it is couched, leaving aside the label that may be given to it, is at its base, it's an indemnification claim, same as 3.
Your Honor, that's my second point, and yes, that's exactly right. My first point is whether you accept the labeling of breach of contract or see the claim for what it is, which is an indemnity claim, the claim seeks to recover for Wells Fargo to the extent Natixis has liability for breaching 2.03D of the PSA. And section 9.12 gives Wells Fargo as master servicer indemnity from Natixis for all liabilities arising out of, related to, or in connection with Natixis' breaches of 2.03D. So Natixis' own claims trigger that indemnity. To the question you just asked, count 1 and count 2 of the complaint that Natixis has pled stay there for breach of contract. But if the court looks, the relief being sought is identical in all 3 counts. And what Natixis is really trying to do is to recast a failed effort to get contractual indemnity, to which it's not entitled, as a breach of contract claim. But in substance, and the court does look beyond the label to the substance, as the Bleecker case holds, where Natixis is seeking to pass off.
Counsel, you're going into your rebuttal time. Would you like to exercise it now?
I'll take another 30 seconds to finish this point and then reserve the rest, Your Honor, if that's okay.
That's fine. Go ahead.
It's clear that Natixis is seeking to pass off its own liability to Wells Fargo. That's the essence of indemnity, however it's labeled. The last point, quickly in 15 seconds, the Court of Appeals decisions in ACE and DLJ make very clear that the notice and cure repurchase provisions of repurchase protocols are procedural prerequisites to suit. Natixis is trying to transform them into a substantive claim. There is no way to square that circle.
Thank you. I'll give you 1 minute on rebuttal. Miss Sullivan, you've been patiently waiting. You're up.
Thank you, Your Honor. Thank you, Your Honor. Kathleen Sullivan for Plaintiff Respondent Computer Share. It is far too late in the day for Natixis to try to raise the borrowing statute for its statute of limitations defense. And Justice Friedman was absolutely correct to hold that new assertion of a new theory barred under the law of the case. Now let's go back and see when Natixis could have and should have, if it wanted to, have raised the borrowing statute. It could have raised it at the motion to dismiss in 2013. It could have raised it in its answer while its appeal from the denial of the motion to dismiss was pending in 2015. It could have raised it before this court, but what did it do? No, it relied expressly and exclusively on CPLR 213 and the 6-year New York statute of limitations. It said that in the record at 56 in its answer. It said that in its briefs to this court at record 477 to 79, 6-year. It might have said any applicable statute of limitations, but it didn't. It said 6-year statute of limitations. And this court held in March 2017 that the action was timely filed. Now, as Justice Manzanet, you said earlier, this court does not issue advisory opinions. That opinion in 2017 is law of the case as to the statute of limitations. And the statute of limitations is one defense. It may have multiple theories, but the time to bring up the borrowing statute was in 2013 or 2015 or 2017, and not for the first time after we've relied on this court's opinion for the last 4 years to complete fact discovery, complete expert discovery, find an astonishingly high breach rate in these reps and warranties that we want to hold Natixis liable for, and it is far too late in the day. So law of the case should prevail. You should affirm Justice Friedman on that ground. Now, my friend, Mr. Newman, says, oh, we didn't have facts. What facts? The Deutsche Bank facts, if they were going to rely on Deutsche Bank as the trustee, were known to them from the deal documents. Deutsche Bank is listed as having a Santa Ana, California address at record 289 and record 570, the deal documents themselves. If they wanted to say, oh, no, it was Wells Fargo that had a California residency. Well, they cite in their reply brief at footnote 5, they cite a 2012 case before their motion to dismiss, in which they say, oh, Wells Fargo might be resident of California. We say not. The comptroller of currency thinks that Wells Fargo NA is resident in either South Dakota or Minnesota, which have 6-year statute of limitations. So, Your Honor, this is the classic case in which we should be allowed to rely on this court's decision as law of the case, as Justice Friedman correctly found, or in the alternative, you could rule, as Justice Gish was colloquy explored earlier, you could rule out 3211E. They didn't plead it in the motion to dismiss. They didn't plead it in the answer, so it's waived. So for all those reasons, Your Honor, Computer Share respectfully requests that you affirm Justice Friedman's decision to strike the belated borrowing statute reference in the supposed amended answer. Thank you.
Thank you so much. Mr. Newman, you have 2 minutes.
Thank you. Thank you, Justice Manzanet. First, just with respect to Wells Fargo is seeking to apply indemnity to an intra-party claim. The Hooper decision makes clear that in order to do so, the contract has to have express language to that effect. That language does not exist here, and Wells Fargo does not address that sufficiently in its papers. Second, Natixis' indemnity claim against Wells Fargo is proper here, and it is completely distinct from the Nomura action. Here, the PSA makes clear that Wells Fargo is to indemnify Natixis for any and all claims and losses that Natixis may sustain as a result of or by reason of Wells Fargo's conduct as master servicer. That is what the complaint is alleging, and it is distinct from the indemnity provision in the Nomura actions that Justice Friedman.
Isn't the provision here broader than that in Nomura?
It is. It certainly is, Your Honor. And so that's how Natixis is applying it with respect to its indemnification claim, which was dismissed by the lower court. The court below read the indemnity provision very narrowly and stated that Natixis can only seek indemnification if the first party complaint by Computershare makes specific allegations as to Wells Fargo's conduct. As you point out, Justice Manzanet, that is not what the indemnification requires. It simply needs to show that Natixis sustained harm as a result of or by reason of Wells Fargo's conduct. The inverse, though.
I just want you, because we do have a limited time for this complicated case, address the claims made by your adversary concerning the Court of Appeals authority that would seem to suggest that breach of the notice provisions or that the notice provisions don't provide a separate cause of action for breach of contract.
Well, first, Your Honor, this court has held on at least 4 occasions, most recently, I believe in 2019, that the failure to provide notice of material breaches is an independent contractual obligation.
We have held that. Were we wrong in light of ACE and its progeny after that? I understand we do have authority that says that. On the other hand, we are bound by what the Court of Appeals says. So explain to me. Go ahead.
Thank you. There's nothing in the Court of Appeals, though, that would require the court to revisit those decisions. And there's also no support for that in this particular pooling and servicing agreement, which requires a notice to be provided to Natixis. Indeed, Natixis bargained for prompt notice in light of its purely backstop obligations here. And so to eviscerate that right would be unfair and simply wrong to do. And also, the Court of Appeals decisions, Your Honor, do not wrap it up. Okay, they don't impact or implicate the independent obligation found in the first paragraph of PSA section 2.03, which you've written about, Justice Gish. And then just lastly, Your Honors, with respect to the borrowing statute, it is, again, important to note that the Deutsche Bank here is not the plaintiff. There are no allegations about Deutsche Bank in the complaint. And so there is simply no record to rely upon or to have relied upon in a motion to dismiss. And Wells Fargo's residence, to the extent it's relevant, again, is in hot dispute as evidenced by the briefs. Thank you, Your Honors.
Thank you so much, Mr. Stanton.
Thank you, Judge. DLJ makes clear that the notice provision provides no basis for an independent cause of action by a sponsor. This court's prior precedent recognizing failure to notify claims has never recognized that a sponsor can sue another deal party for not having been provided notice of its own breaches. DLJ involved the same type of backstop obligation that's at issue in this PSA. And here's what the Court of Appeals said in the DLJ case, quote, RMBS notice and sole remedy provisions are not substantive elements of the cause of action, but instead limitations on the remedy for a breach of R&Ws. They serve as a precondition, a procedural prerequisite to suit, not a separate undertaking. So they cannot form the basis for a claim. And on indemnity, just on the indemnity provision, the indemnity that Natixis is owed is far narrower in causal scope and in the linkage to liabilities at issue than the indemnity that Natixis owes Wells Fargo. Natixis owes Wells Fargo specific indemnity for repurchase-related liabilities.
Thank you so much.
Thank you.
People v. Balo. Mr. Blakemore, you have 6 minutes.
Thank you, Your Honor. Good afternoon, and may it please the court. This is Patrick Blakemore, and I represent appellant Marty Balo. In this appeal from an assault conviction arising out of an altercation at a bodega in Harlem, the dispositive point is not in dispute. Mr. Balo was convicted of first-degree assault and attempted first-degree assault as a principal, despite incontrovertible evidence that he never touched either of the weapons in question. On that basis alone, his conviction should be vacated because principal liability requires that the defendant cause injury to another by means of a dangerous instrument.
Mr. Blakemore, can you address the people's argument of gamesmanship on the part of the defense?
Happily, Your Honor. What occurred here was that there was a charge conference. At the charge conference, the parties were asked whether they had any additions to the instructions that the court intended to present to the jury. At that time, accessorial liability was not raised. There were other things discussed, including a justification defense that was denied and the addition of a lesser included offense of third-degree assault. Following the instructions to the jury, the people raised a question as to whether accessorial liability should have been presented, and the court said that was what the charge conference was for. The people suggest that counsel below for Mr. Balo should have essentially agreed that accessorial liability should have been presented to the jury at that time, but there was no obligation for him to do so. The charge conference had already occurred. The parties had had their opportunity to decide what they would ask the judge to instruct the jury on. And so to suggest that counsel for Mr. Balo should have effectively lowered the bar for conviction by allowing an untimely presentation of accessorial liability that was not asked for before, I think is a little bit absurd in some respects. I don't think there would be any obligation, nor could there be any reason for counsel below to effectively agree to make it easier on the people to convict his client.
And did the court ask both defense and the prosecution what it thought about the issue of accessorial liability?
The colloquy that occurred at sidebar did ask only Mr. Balo's counsel whether he wanted to add the charge of accessorial liability, presumably because the people had already had the opportunity, if that was the theory of conviction on which they wanted to rely, to prevent that during the charge.
My point is that on the record, the court asked defense. Defense said no, that you did not join in that request, and then spoke to the prosecution, who, as I recall, did not object and acquiesced.
I agree, Your Honor. I don't think that the people actually raised a proper objection to the refusal to submit accessorial liability to the jury. If you look at the transcript where this colloquy occurs, the people effectively say, okay, when the judge acknowledges that the charge conference was the opportunity to raise an additional theory of liability that the people might have wanted the jury to convict on. So what ultimately is happening here is that the people are asking this court to affirm a conviction on a theory of accessorial liability, which was never presented to the jury because the people didn't ask for it. And of course, the court did not then charge it. Accessorial liability is unique. This court has repeatedly held that in order to hold someone accountable for the crime of another, it is essential that the jury be properly instructed on the principles under penal law, section 20. That did not occur here. The jury instructions are unambiguous and the people don't dispute it. And the people have not identified any case in which an appellate court in New York State has affirmed an assault conviction as a matter of accomplice liability when the theory was not presented to the jury below. And whereas here only principal liability is on the table, there's also no authority to support a conviction when the defendant never touched the weapon in question. And this makes sense because on appeal, right, the sufficiency and weight of the evidence are reviewed relative to the legal theories and standards presented to the jury in charge. This is a first principle of appellate review. This court doesn't expand on the facts found or the law charged below because the trial court record forms the perimeter of this court's analysis. And that's true even if this court might believe that the evidence would support a finding of guilt by accomplice liability. The Court of Appeals decision in Dlugosch held the same. There, the court said, we think that the evidence might support a finding of accomplice liability, but because it wasn't presented to the jury below in the charge, it was out of the case. The people in their brief say that Dlugosch is an outlier, but that's simply incorrect. Numerous cases from this court and its sister courts in this state cleanly establish that the appellate court is not in the business of considering hypothetical charges and theories of liability. You can see those cases at pages 16 through 22 of our brief. And
Thank you so much.
Thank you.
You have 2 minutes on rebuttal, okay?
Thank you.
Mr. Shi, you have 6 minutes.
Good afternoon, Nathan Scher for the people. May it please the court. Your Honors, defendant's argument on appeal is not only unpreserved as he concedes, but it is waived. When the trial court specifically asked defense counsel if he wanted an accessorial liability charge included in the jury charge, defense counsel expressly declined.
Why should he have accepted that? You say that like he did something wrong.
I don't think our argument is that he had to have accepted the charge for accessorial liability, rather that he took the position that, defense counsel took the position of not having accessorial liability charged to the jury when.
So I don't know that that's accurate at all. So the people had a chance to ask that the charge be included at the charge conference. That we know.
Correct.
It didn't happen. People didn't do that. Subsequent to the charging of the jury, there was a colloquy, right, up at the bench, and there was an opportunity for the people to make its position known. But that didn't exactly happen because the people barely said anything. I don't know that you can shift your responsibility to defense counsel. If defense counsel had said, sure, add it at this point in time, wouldn't that have opened defense counsel to an accusation of ineffective assistance of counsel? Wasn't this your burden as the people, not you personally, but wasn't this the people's burden?
Your Honor, how I would respond to that is first that it's the people's position that they did ask for a accessorial liability charge, albeit it was a short colloquy.
I'm sorry. When did you ask for the accessorial liability charge?
I apologize. After the jury was charged, the people agreed
that is really problematic, right? Because here, adding the accessorial liability charge would have required a completely different summation.
Well, Your Honor.
So adding the charge after summations would have inured to the prejudice of the defense.
Your Honor, my response to that is that the entire case was grounded in accessorial liability. Both parties had talked in summation as well.
I know you say that, but the charging instrument didn't have anything about accessorial liability, did it?
That's correct, Your Honor, but
no. But that didn't preclude you from making it part of the trial. That's true too, right? We know that.
Correct, Your Honor.
But you still had to ask the court to make it part of the legal theory during the charge conference so that the parties knew what they would do during summation. They're different theories of liability, principal liability and accessorial liability, right?
Well, Your Honor, it's well settled that there's little distinction between principal liability and accessorial liability. Excuse me,
what?
Liability.
Are you kidding? What? Are you kidding? You have to prove the same intent. And you can't prove it by their doing the crime because they didn't do the crime. They were an accessory.
Well, Your Honor,
It's different. It is different.
There are no different elements for liability as a principal versus liability as an accessory. It's the same.
And why do you need another instruction? Why do we have another instruction?
Well, Your Honor,
it's different. Honestly, I can't accept that.
Your Honor, it's the people's position that the accessorial liability charge is designed to help a jury recognize accessorial liability more easily. And it's particularly helpful in cases where an accomplice is less involved. But here, and
let me ask you a question. Then how do you? I know you're saying that. How do you distinguish the Dulagish case, which is a Court of Appeals case? It seems to hit that very point right on the head and says, no, it's something different. And if you don't charge it, then we can't even look at the theory or affirm a conviction on that accessorial liability theory. That's what they said.
Well, the way that
we would actually kind of critical of what went on below.
The way the people would distinguish Douglas is that in that case, at the close of the case, the trial court dismissed the portion of the indictment which charged that defendant had acted in concert. Affirmatively, I believe that court said it effectively granted a trial order of dismissal as to that count. Where here, there was no such pushing out the theory of accessorial liability affirmatively.
Well, actually, that provides a stronger case, doesn't it? Because it was a judge's mistake. Here, it was in your hands, and you didn't take the ball and run with it at the right time.
Counsel, the people didn't even take exception. I'm looking at the colloquy here. Any exceptions? And the people say, I realize it's accessorial liability. The court says nobody asked for it. People say it wasn't included. The court says a few words, do you want me to give a charge on accessorial liability? Defense says, no, thank you. Court says, okay, that's what the charge conference was about. And the people say, okay. So haven't you given up on this? Can you really rescue this situation at all? And mind you, we're cognizant of the factual allegations here. They're pretty serious.
Well, if I may, I believe a strong argument that we have is that like you said, the factual allegations are incredibly serious, and I urge the court, if it has the time, to look at the video itself and see how in tandem the defendant acted with.
Counsel, the video shows what it shows. It doesn't change the defect in the charge. Thank you. We have your arguments. Mr. Blakemore, you have 2 minutes.
Thank you, Your Honor. I'd like to briefly make 2 points. Counsel for the people indicated that there's no distinction between accessorial liability and principal liability. That proposition comes from a number of fair notice cases where the idea is that when the indictment only charges the defendant as a principal, it is not expanding the scope of liability to then consider both accessorial liability and principal liability during the trial and to charge on those bases. That's distinct from what we have here because the charge itself, what was presented to the jury, what they were asked to consider, was exclusively principal liability. The second point I'd raise in response to counsel is that he indicated that everybody knew that this was a case about accessorial liability. My response to that would be say everybody but the jury. They weren't asked to consider that theory. And it is not the summations or the opening statements or any other time that the advocate opens his mouth. That's not sufficient for as a substitute for an actual jury instruction advising the jury of what's necessary in order for them to convict someone as an accomplice under Penal Law Section 20. That instruction wasn't given here. Thus, the only reasonable conclusion is that Mr. Balo was convicted as a principal of first-degree assault and attempted first-degree assault, and the evidence is woefully sufficient to support that conviction. Thank you.
Thank you so much. Harris versus Structure Tech. Mr. Tripp, you have 4 minutes.
Thank you, Your Honor, and may it please the court, Noel Tripp for the appellant defendant, Mr. Cormican, as well as the non-appealing defendants below. There are several legal theories asserted in this case against the appellant, sued in his individual capacity, but as an owner of the corporate defendant. I wanted to begin with the human rights law, the discrimination statutory theory, as I believe the court has recently addressed this issue several times in two opinions that have Judge Manzanet's name on them, albeit one in dissent, which remains on appeal. So that would be the Bloomberg case. And then recently this court in November affirmed Wolf. And Wolf to us stands for the proposition that as some alleging a discrimination complainant alleging that they had a conversation wherein the other party to that conversation implied that a third managerial person, in the case of Wolf, the head of the gaming commission, and here Mr. Cormican, said or did things that might tend to be discriminatory. I'm referring to paragraph 22 of the amended complaint, which is 143 in the record, which is of course denied, but that's not the purpose we're here for today. So to us, those cases direct the decision here. Justice James Balo cited to Lancer, which was a more traditional individual owner was told that charging party plaintiff was pregnant and then made the termination decision his or herself. Turning to the New York labor law cause of action, which is asserted against Mr. Cormican, the order below simply didn't address that cause of action, and there are no facts relating to Mr. Cormican, again, as the individual employer alongside the corporate entity, as opposed to on a corporate veil or our alter ego theory as a directly statutorily liable individual employer. And then finally, but relatedly, there are several tort causes of action. And again, Justice James relied on D'Amico, where there was a straightforward holding that if A, B, and C all made certain statements directly to the authorities, as was also at issue in this case, the employer non-appealing defendant did make a report of stolen equipment, that all of those individuals could then be held liable potentially for those torts. This is not that scenario, and now I'm addressing what we think are the key allegations at 146 and 147 of the record, where plaintiff, only upon amending the complaint, added an allegation upon information and belief that the actor, non-appealing defendant Boswell, who is alleged to have done things, couldn't or wouldn't have done those things without consultation with the appellant.
Thank
Mr.
you.
Ford.
You have 1 minute in rebuttal.
Thank you, Your Honor.
Mr. Newhouse, you have 4 minutes.
Okay, thank you. I will address the discrimination issue first. The case that the defendant cites with Doe versus Bloomberg basically says that, and I'm going to quote from it, a plaintiff must allege that the individual has an ownership interest, which plaintiff alleges in this case, or and in addition to that, must allege that the individual encouraged, condoned, or approved this specific conduct. In this case, the plaintiff expressly alleges that the individual defendant told the supervisor that he will not provide a raise to the plaintiff because he is African American, which is the basis of the discrimination claim. So it meets the criteria set forth in the First Department's decision in Doe v. Bloomberg. With respect to the labor law claim, plaintiffs turned the court's attention to the Bonito case, Bonito versus Avalon Partners, where in that case, the plaintiff was held to have sufficiently alleged employer liability by alleging that the owner had that had control over the day-to-day operations, and also there was an affidavit submitted where that said that the owner had the power to fire employees, supervise and controlled employees, work schedules, determine the method and rate of pay, kept employment records. Plaintiff makes all the basically identical allegations in the complaint. The fact that it was an affidavit really doesn't matter. That affidavit was submitted to basically remedy a defect in the complaint. But here, there was no defect. That there was already in the complaint those allegations. Not to mention that those allegations were in the first complaint, which was verified. The first complaint was a verified complaint by the plaintiff. So, to the extent the fact that the subsequent affidavit was submitted, it shouldn't make a difference. And lastly, with the defamation, malicious prosecution, and abusive process causes of action, yes, there's reliance on D'Amico, but the primarily rely on Brown versus Mack. It's this 1945 decision where basically the court held that the individual who procures or directs the exact language is all who take part in the procurement, composition, and publication of a libel are responsible in law and equally so. Here, the plaintiff alleges that that the plaintiff alleges upon information and belief that he was directed to file that the supervisor was directed to file the police report, and that's based on a number of facts. The main one is that the plaintiff employee alleges that the supervisor would not have acted if not for the direction and authority from the owner. I mean, this is what it was alleged that he stole something, and the standard on a motion to dismiss is that everything has to be assumed true. All facts alleged must be assumed as true, and so here it was stolen company property. So it's fair to infer, it's reasonable to infer that the owner was the one that instructed the supervisor to go to the police and report the stolen property from the company, especially because it's alleged that the owner and the supervisor had weekly meetings, and the supervisor went to the owner to get the authority to provide a raise for the raise to the plaintiff. So there are numerous facts in the complaints that support the allegation that it was defendant Appellant that directed the supervisor to go to the police to file a false report.
Thank you so much. Mr. Tripp, you have 1 minute.
Thank you, Your Honor. As concerns the discrimination facet, I don't know that we have a dispute about what Bloomberg v. Doe says. Obviously, the allegations in that complaint were fairly extensive, if all treated as facts. They pulled from deposition transcripts, and they alleged that the corporate owner, Michael Bloomberg, encouraged certain behaviors, and that was all deemed insufficient to us. Wolf,
Counsel, these cases could not be more different, since in the Bloomberg case, at the time of the incident, Bloomberg was the mayor and was no longer in control of his company. That is not the case here.
No, Your Honor. And hence our reliance and emphasis on Wolf, where Ms. Lee, the appellant individual defendant, was similarly where the plaintiff's allegation was based on what somebody told the plaintiff about Ms. Lee's ostensible direct involvement, direct role in discussing the disability.
Right. Somebody has a mic on or a telephone on near their computer. It is creating feedback. I need you to turn the phone off or get it away from the computer. Please continue, Mr. Tripp.
Thank you, Your Honor. As concerns the tort theories, I think the plaintiff is attempting to confuse a respondeat superior theory where a tort could potentially be imputed to the corporate employer, and if meeting the if alleged to be the employer, the appellant here, Mr. Cormican, and an actual publication of statements oneself, which isn't alleged. And finally, as concerns the labor law, we recognize that Bonito holds that under inappropriate cases, the economic realities test would apply under Article 6 of the New York labor law. There simply aren't any facts or averments in this complaint other than a statement of what that test is to support individual liability as opposed to corporate liability.
Thank you so much.
Thank you, Your Honor.
CRG Financial LLC versus Amloyd Corporation. Mr. Eisenberg, you have 5 minutes.
Good afternoon. Good afternoon, Your Honor. It is well established.
Okay, Mr. Eisenberg?
Yeah.
Do you have a phone on near your computer, because the feedback is coming very strong from you?
Yeah. How's this? This better?
Much better. You may
Okay.
proceed.
My apologies, Your Honor.
No problem.
Okay. It is well established that courts may not disregard or add new terms to clear contract language to alter an agreed upon bargain between the parties. And respectfully, that's what we think the Supreme Court wrongfully did here. My client's an investment firm. They purchased bankruptcy claims. They purchased a claim from the defendant in the Toys R Us bankruptcy proceeding for 70 cents on the dollar. The terms of their agreement is governed by a claim purchase agreement. In a bankruptcy case, the debtor files schedules. Those schedules reflect the creditors of the debtor on the debtor's books and records. The agreement has a refund provision in the agreement, which says if the claim is not listed by the debtor on its schedules, my client is entitled to a refund. There's a good reason for that. If the claim is not listed on the debtor's schedules, then the debtor has not acknowledged the existence of the claim. If the debtor hasn't acknowledged the existence of the claim, then the validity of the claim is in question. And from my client's standpoint, it's likely to be objected to. In bankruptcy cases, objections last for years, and my client didn't want to buy into a contested claim. I think he has the right to do that. A creditor can also assert their claim by filing a proof of claim, alternatively. But the agreement specifically addresses the instances where a proof of claim is filed. In paragraph 2 of the agreement, it states that the seller, meaning the defendant, represents and warrants that if it has filed any proofs of claim, those proofs of claim have been provided to the plaintiff, the buyer. And if the buyer, my client, becomes the owner of the claim, subject to the terms of the agreement, which would incorporate the refund provision. So the agreement specifically addresses the instance where a proof of claim was filed. In this case, the defendant had not filed a proof of claim, so my client filed one to assert the interest. The claims were not listed.
So in essence, your argument, if I may, is that your client's filing of that proof of claim does not cure their defect and their breach by not submitting it onto the schedule.
Does not cure the fact that the claim was not listed by the debtor on the debtor's schedules.
And thereby triggering the duty for them to pay your client their purchase price.
Correct. That is correct. So the claim wasn't listed on the schedules, and my client filed a lawsuit because the claim wasn't listed on the schedules. The court below granted summary judgment to the defendant dismissing my client's claim for the following reasons, which we think are incorrect. First, the court ruled that there's no distinction between a proof of claim and a scheduled claim for the purposes of the creditor's assertion of the claim. While that might be true under bankruptcy law as far as the claim, there is a distinction. This is between my client and the defendant. And the distinction is, if the claim isn't on the schedules, the claim is in doubt, we can file a proof of claim, but we think it's likely the claim's going to be objected to. We want an acknowledgement by the debtor that the claim is valid. But even if there wasn't a distinction, even if the court was correct, the agreement specifically addresses a proof of claim. And the agreement says that if a proof of claim was filed, my client becomes the owner of the claim subject to the terms of the agreement. And the agreement specifically incorporates the right to a refund in the event the claim is not listed on the schedule. So that's a freedom of contract between two parties. And I think in New York, freedom of contract is a very, very strong public policy. The court also made an error when it said that the refund provision was incompatible with a provision that says that if the claim is valid, my client agrees to accept the bankruptcy recovery, which is correct. My client is assuming the risk that if the claim is valid and they pay 70 cents on the dollar and the claim pays 20 cents on the dollar, my client takes that risk. We agree with that. But the fundamental error of the court was the court ruled that the filing of a proof of claim establishes the validity of the claim. So that according to the court, the claim was valid merely by filing the proof of claim. And that is just incorrect.
Thank you. You have 2 minutes on rebuttal, counsel.
Thank you, Your Honor.
Okay. All right. Mr. Torf, you have 5 minutes.
Thank you, Your Honor. Jason Torf for the respondent. Your Honor, this is a case of sour grapes looking back after the fact at a claim
for— Can I ask you a question, sour grapes notwithstanding, just looking at the contract. The contract says that if the debt is not listed on the schedules, then there is, that the seller agrees to make purchaser immediate proportional restitution and repayment. What's the purpose of the word immediate in there?
Your Honor, we didn't draft the contract. I'm not sure what the purpose of immediate is.
You signed the contract. So what did you understand immediate to mean?
Frankly, I don't think the word immediate has any particular meaning. They have the right to go seek to collect if they believe a restitution event has been triggered. And they have the right to seek it immediately. And we can certainly contest that a restitution event has been triggered, but they can't.
Do you disagree that under the contract language, your client has an absolute obligation to file the debt on the schedule and that they did not meet that obligation here? Is there any issue about that?
Your Honor, please allow me to clarify something. A creditor such as Amloyd here does not file the schedules. Schedules in a bankruptcy case are filed by the debtor. Debtor files schedules listing all of its unknown creditors and amounts that they owe. So
So is there a different risk? Is there a different risk on the debt when the bankrupt puts you in the schedule as opposed to having to file a proof of claim because it's not listed? Is the risk of payment different in bankruptcy when that happens?
No, it isn't, Your Honor, particularly where large companies file bankruptcy, such as Toys R Us. Their books and records can be a mess, and not being listed on the schedules does not necessarily mean that the claim will be objected to. And in fact,
but it could mean, right? They can't object to it if they put it in the schedules, right? Toys R Us couldn't object to it if it was put in the first instance.
They can, Your Honor. A scheduled claim can be objected to, and schedules can be amended in a bankruptcy case to remove or modify a claim. So even if it's listed on the schedule.
Counsel, isn't the dispositive aim to have the higher bankruptcy priority placed on the administrative expense claim? Isn't that the whole purpose behind having to put it on the bankruptcy schedule?
No, I don't think that's the purpose of the higher priority claim, Your Honor. The schedules are simply a listing by a debtor of all claims the debtor believes that it has. And frankly, administrative claims aren't always listed. In this case, some were, some weren't.
This agreement required you to list the claim, right?
No, again, Your Honor, it's not us that has an obligation. It's the debtor, the company in bankruptcy, that has the obligation to file the schedules and list creditors. Right. And the restitution trigger here that they're claiming is that the claim wasn't listed on the schedules. That's something that's not in our hands. That was in the Toys R Us's hands. Yeah,
and Toys R Us didn't do it.
Toys R Us didn't do it. And then once the proof of claim was filed, it's black letter law at this point. Bankruptcy Rule 3003C4 says that once
that may very well be, counsel, but the contract has very specific language. So are we to ignore the specific language, or is that language just superfluous?
This is like the transitive property in math, Your Honor. A equals B and B equals C.
Counsel, I really, that doesn't get you anywhere with me. Okay?
Well, Your Honor,
I'm asking you a very direct question.
No,
and you have yet to answer it.
I'm sorry, Your Honor. You do not have to ignore the contract language. The fact is that filing a claim is the same as being listed on the schedules, so that what they claim to be
not the same, because the contract required it to be done at the outset by Toys R Us, and it wasn't.
The contract doesn't require it to be done. The contract simply says if it's not listed on the schedules, they may claim a restitution. But again, a proof of claim filing is the same under Rule 3003, Bankruptcy Rule 3003, as being listed on the schedules. That's what Rule 3003C4 says.
Thanks so much. You're out of time.
Thank you, Your Honor.
Mr. Eisenberg, you have 2 minutes on rebuttal.
What happened to you?
You're on mute, Mr. Eisenberg. You're on mute. Unmute.
Can you hear me now?
Yes.
Okay. If the defendant wanted to negate the refund obligation, if a proof of claim was filed, there could have been a provision in the contract that said if a proof of claim is filed, the refund obligation is negated. The defendant did not put that into the contract. The court can't put that into the contract for him. And if the defendant didn't like that provision, he didn't have to sign the agreement. This is an agreement between two parties, freedom of contract. They don't like the way it worked out, apparently, and now they're trying to buyer's remorse, I suppose, or buyer's remorse, seller's remorse.
Well, I guess they have buyer's remorse. You have sour grapes. We have the contract. Yeah.
And with that, I bid you all.
That's why the language of the contract should govern, because everybody has a gripe. Look at the contract. What does the contract say? That's the way the case should be decided in our view.
Thank you so much. Have a good night.
Thank you.
Valbuena versus 650 Madison. Mr. Ryan, you have 4 minutes.
Yes, good afternoon, judges. My name is Kevin Ryan for the defendant appellants, 650 Madison Avenue. The issue here is the scope of work under this contract between Americon and 650 Madison. So what Americon argues is that because the plaintiff was not doing the work of its contract, which is fine cleaning, which was excluded under the contract, that it doesn't come under the scope of work. But the scope of work here, and in cases that this court has interpreted, is far broader than just the actual work being performed or not being performed by Americon. In this particular case, the scope of work is defined by the contract. It's in section 1.1. And in that section, what it states is that the scope includes all labor necessary to complete such construction and all materials and equipment, whether for temporary or permanent use, incorporated or to be incorporated in such construction, all tools, etc. What happened in this case is, as part of a change order to the contract, there were convectors or radiator covers that were installed. This particular gentleman, Mr. Valbuena, was involved in window washing, and as many window washers have been known to do, he used this radiator cover in order to do his task, and he fell off this radiator cover in descending this. What he claims, and his expert claims, the plaintiff's expert, is that it was slippery, that his foot got entangled in duct tape, and that there was protective covering that was not there. But what's critical for this is that the scope of work included also equipment and tools, and this accident involved those a piece of that equipment, in this case, the convector and the tools, so that in this case, even though he wasn't doing the work of that trade contractor, it involved their scope of work. And this court has, in a number of cases, and I'll point out as my brief has, in the case of Urbina versus 26 Court Street, the citation 4683 268, and in Wilk versus Columbia, 150, 502. In both of those cases, the court noted that the particular person who was injured was not doing the work of the trade contract for which indemnity was sought, but there was equipment. In the case of Urbina, there was a scaffold that they had provided that this masonry contractor or the electrician was using, he shouldn't have been using, and even though he wasn't doing the work of the masonry contractor, the court found that there was it was within the scope of their work for indemnity. Now, the second issue here is the scope of the indemnification language, and this scope couldn't be any broader, and that's also on page A108 of the record.
So,
and
Counsel, are you referring to 4.3 of that's in the appendix where it says that even contractors that are retained directly by the owner are covered? because of American's work safety obligations?
Right now, I'm referring to the indemnity language, and the indemnity language is, and that talks about all claims which arise out of or are connected with or claimed to arise out of or connected with. This is the very broadest type of indemnification here. Now, my colleague or the respondent has been arguing that this indemnification, it means that there has to be a liability finding against them, which is clearly not the case. All of the cases that we've cited, the underlying cases of negligence and labor law have been dismissed against the individual contractor, but the court has still found that that contractor owed indemnity based upon language like this. And I'll point out that in the cases that this court has—
Why don't you save that thought for your rebuttal time? We're out of time. Okay, great. Mr. Torp, you've got, I'm sorry, Ms. Ritzer. You have 4 minutes.
Thank you, Your Honor.
My apologies for mangling your name.
That's okay. If that's the worst that happens to me today, I'm good. It is a privilege for me to represent American before this court on this historic day. And when we take a look at the issues that have—
You just muted yourself.
Mute.
Just muted yourself.
Yeah.
Sorry. Okay.
Thank you.
Thank you. On behalf of American, we believe that the court correctly denied 650 Madison's motion for contractual indemnification, and we believe that American is entitled to summary judgment in dismissing those claims. In particular, we need to take a look at the timing of this and the actual contracts that we're talking about. This is a situation where the insurer who assumes 650 as offense, which is BMS's insurer, is now trying to ignore the contractual obligation and the indemnity obligation that BMS has, and that BMS actually undertook to 650 when it assumed the defense and indemnity of 650 in this case. Here, in 2014, 650 Madison Avenue entered into a cleaning contract with BMS. And in that contract, it included the fine cleaning within the building and the cleaning of the windows. A year later, they entered into a construction contract with American to do certain work within the building. Expressly excluded in the American contract on a record of A-117 is repairs to the existing buildings, and it includes fine cleaning. 650 Madison has repeatedly stated that on page 6 of its appeal, a brief on appeal, and on page 11, that there was fine cleaning. The plaintiff was engaged in fine cleaning. That work was expressly excluded. It's also interesting to note that counsel for 650 Madison never has yet to say, and I kind of liken it to, and I was thinking about this, I kind of liken it to a snow globe. When you take a snow globe and you shake it and you get all the white particles or the sparkles, you can't see the figurine in the center of it. The figurine in the center of this case is the contract with BMS, and they want to ignore that. On page A-20 of the record, 650 Madison Avenue expressly stated that Valbuena's work as a window washer for BMS General Services. A complete copy of the contract between BMS Services and 650 Madison was attached as an exhibit. The terms clearly set forth that BMS Services included window cleaning. As to this and other services provided in the contract.
Could you address the fact that American's responsibilities included its sole and primary responsibility for the safety conditions at the work area? Isn't that dispositive here?
No, it's not, Your Honor, because American did not have the coordination. On page section 4.3 of the contract on page A-104 of the record specifically states that the owner reserved the right to contract work with other contractors, and those contractors are to control the BMS contract. And as American's own counsel,
the way I read 4.3 was American was required to coordinate its work, and work includes safety, with other contracts on this. This is the question that I posed before to Mr. Ryan at the wrong time, apparently. Other contractors on the site, including contractors retained directly by the owner. So doesn't that mean that American's responsibilities went beyond the fine cleaning limitation that you just referenced?
No, Your Honor, because American did not have the right to direct, supervise, and control the actual work of BMS. And this court, and Judge Gish in Napari versus Murray, specifically made that distinction. Here, BMS and 650 Madison expressly states that in the record on page A20, that the sole discretion to determine the manner and means by which its employees would perform the work was expressly with BMS. Now, all of a sudden, since we have BMS's insurer trying to derive the boat here, now they're trying to place this blame onto American. That work was expressly excluded and placed squarely with the entity that's employee. It was supposed to, and 650 Madison Avenue has acknowledged this over and over. It was BMS that was supposed to direct, supervise, and provide the correct equipment. The issue here is the plaintiff didn't use the correct equipment. The plaintiff had ladders and tools to be able to do his job without having to step up in a convector. We're talking about a convector. A convector is not a scaffold. It's a heating unit that was never intended to be used as a safety device. It was misused. The American did not have the right to tell BMS, and those rights as to direction, supervision, and the proper equipment rested solely with BMS.
So you're saying that American's responsibilities didn't supersede that, warrant an overall responsibility for everything that was done there?
I'm going to allow you to answer that question, Ms. Rizzard, and then you're out of time. Go ahead.
For this particular work, yes, Your Honor, because as 650 Madison Avenue points out, and they agree with American, that this was solely within the exclusive control of BMS as part of its contract. When we look linear here, there's a privity of contract between 650 Madison Avenue, and the indemnity provision isn't so broad as counsel would like to say in Valbuena. Is that we didn't accept all work. We didn't accept that it's for the work that was performed on the agreement. This was a specific carve out, and it was a specific obligation that BMS accepted that 650 asked BMS to do. They assumed it. They accepted that responsibility. And now they're trying to offshoot that liability onto American when it doesn't exist.
Thank you.
May I
Anything else?
Yes, may I
You
address
now
your
have to, Mr. Ryan, give me a moment to call on you, okay?
I apologize, yes.
Not a problem. You now have 1 minute in rebuttal.
Yes, Judge Gonzalez, I apologize. I didn't address your question. So what you point out is true, that this was part of a construction project. And while counsel wants to say that the BMS worker, they had sole responsibility for that, what they were doing, this fine cleaning, was part of the overall construction. The construction job is not over as of yet. And as you point out, under this particular contract, which anticipated that the owner would use different contractors to do different tasks, that the responsibility for safety and for coordination continued to rest with American at all times. And so they made the point.
What was the purpose of the exclusion for the fine work?
So it wasn't part of their work. They weren't doing the fine cleaning. Although what he was, so it would be like saying a trade contractor, you're doing electrical work, but you're not doing something else. However, as these other cases that I cited to talk about, that doesn't limit the indemnification obligations if it involves tools or equipment that contractor was using, and as the judge points out, something that they were responsible for in terms of coordinating and scheduling. What he fell off of, even whether he fell off of a piece of equipment that was installed as part of their work, a convector, which is part of the change order, and he fell, according to the plaintiff and according to their expert, the claim is that he fell because the convector's condition, that the convector was too slippery, that it lacked protective covering, and that he was using that as a work platform, and that was one of the causes of his accident. So within the context of this construction, we were doing one aspect of that construction, or part of that problem, but the construction was ongoing at that time, and American was responsible for that work of coordinating and scheduling. And the issue has been raised about BMS. The court has dismissed any claims in negligence or labor law as against 650 Madison, which would give us the opportunity at this point to enforce the indemnification if the court were to reverse the lower court's decision.
Thank you. Okay. Garner versus DHCR. Mr. Mitchell.
Good afternoon, Your Honors. It's Joseph Mitchell representing the appellant. The appellant brings this appeal. The appellant brings this appeal to overturn a decision by DHCR which found that the owner's submission of an invoice and 2 canceled checks dated January 2012 was sufficient to establish individual apartment improvements totaling $42,000, which in effect raised my client's rent stabilized lease by approximately $700.
Sir, excuse me, this is Judge Schulman. But didn't the owner comply at the time fully with policy statement 9010?
And this is what we are contending, Your Honor, is that DHCR was acting arbitrary and capricious in that if you look to Operation Bolton 2016-1.
Yeah, well, that's the point, sir. I'm aware of the latter operational bulletin, and again, I don't mean to digress, but we've seen a line of cases, for example, the Altman decision, the Regina decision, that generally tends to focus on what the law was in effect at the particular time an action was taken. So right. You can't really challenge the fact, notwithstanding whatever changes took place in the operational bulletin later on, that policy statement 90-10 allows a property owner to submit invoices and cancel checks without more to corroborate the work that your own client acknowledged was taking place, putting aside the timing, whereas the proven costs appear to be on a certain date while your client claims the work was still ongoing through the summer before he commenced occupancy in the fall. But you can't dispute the fact that this record before the DHCR, as well as well-settled case law, allows the DHCR to consider that kind of documentation to corroborate the IAIs to justify that that increase above the longevity increase and the other allowances to get the rent over $2,000.
Your Honor, sir, with reference to that, our position is, besides, as you stated, about the timing and a violation of even Operational Bulletin 90-10, but what we're stating is if you read
what he said,
can you hear me?
Yes.
Okay, 2016, it's quoted in that statute. However, actual processing has shown that more than one type of proof is the norm rather than the exception. That's in the statement in the Operational Bulletin 2016-1. So the customary practice at that time for DHCR was to seek more than one submission.
But aren't we bound by the rule that was in effect at the time?
Which they acknowledged wasn't being, that the norm and the customary practice of DHCR was
norm, and I am talking actual rules. And this court and the court below had to utilize the rule then in effect, not the one that was later amended years after this case.
But they've acknowledged that the customary practice.
Right, counsel, we don't have to argue this point. Do you have another point you'd like to make?
No, I'm fine.
You have no other arguments other than this argument?
We have also, yes, Your Honor. There was.
I don't want to cut you off from the rest of your arguments, but it doesn't serve you to debate us on this point.
Okay, as to the remaining arguments, we once stated that the payments were not contemporaneously made. Our client states that on July, before he was going to rent the apartment, which is over 6 months from when they allegedly paid the invoice, the owner, that he saw the same repairs and or individual apartment improvements that were already paid for back 6 months. It was not contemporaneously when the work was complete. He saw kitchen cabinets being installed, and he saw many other of the things they claimed were done back in January.
I thought the allegation was that appliances were being installed.
There were appliances, and there was also kitchen cabinets were in the paper.
I thought the records talked about appliances and hardware,
and the appliances were
not
inflated.
the actual cabinetry.
And then the appliances were inflated, is what we're stating, to justify a fraud claim.
Is there, I'm sorry, sir, is there any case law that I'm aware of that mandates that a property owner use the most cost-effective approach to IAIs versus the actual cost? In other words, I know you got other opinions to suggest that the cost should have been 50% less.
Correct.
You know, and that's fair, and I can appreciate that. But the reality is I'm unaware. If you can bring it to my attention, I would love to read it, and before I make my final decision here. But I'm unaware of any appellate case law or even any DHCR requirement that mandates that a property owner use the most cost-effective, I hate to use this word, cheapest way of installing improvements to give the rent increase a minimal versus a maximal approach. Is there anything like that on the books?
I have not found any supporting case law or decisions from DHCR. But
and nothing from this court, nothing from an appellate court.
Not that I'm aware of, no.
Okay, Mr. Mitchell, you'll have a minute on rebuttal, okay? Ms. Joseph, DHCR, we'll hear from you now. We can't hear you, Ms. Joseph.
Sorry, forgot to unmute me.
Okay.
I just wanted to say that this case was actually transferred. There was no decision by the court below because the court erred in saying that there was an evidentiary hearing and therefore.
Right. I think you may be right on that, but there's nothing that stops us. And in fact, I just wanted to point that out. You anticipated what I was going to say, which is that can't we just get to the merits on this?
Exactly.
But it's arbitrary and capricious. That's the standard we're looking at.
Right.
Right. Okay.
Very quickly, DHCR just followed the rule in effect at the time, which was 90-10. The tenant never said that the improvements weren't completed. As a matter of fact, they sent in a letter from the tenant next door that said that the apartment was uninhabitable because the tenant was evicted. They never challenged that the improvements were made.
Yeah, that's kind of, it was curious to me that they did that because that didn't mean that that improvements weren't made to the apartment. It sounded like that was the reason that they had to do a lot of work to the apartment.
I was surprised. We were surprised, and that's why we went with the decision, because even though they got architects' estimates, which were submitted the first time on par, which is, you know, in violation of 29, you don't submit evidence for the first time on par, that they said, oh, it could have been done cheaper. But that was submitted.
Did they raise that before the first time, or only on the par that it could have been done cheaper?
It was only on the par.
So we couldn't even look at that, assuming that they gave proof. The DHCR would have at the beginning level, at the hearing level, if they were provided with that information, then the hearing officer could have accepted it or not accepted it, correct?
Right. But on par.
Same thing with on the par. There was an argument made, but that couldn't be considered about whether the contractor doing the work and the owner of the apartment building were interrelated, which would have raised some concerns, correct?
Precisely. If even with 90-10, if it was raised before the RA, we may have looked at it, but the evidence that was submitted that there was fraud because the improvements were at a higher cost, and these architect reports were conducted 6 years after the improvements were installed. So there's no way for anybody to tell what condition the apartment was in when the tenant that was evicted, where the tenant next door said it was in uninhabitable condition. You don't know how far they really had to go.
Well, she gave us painstaking detail about how awful the apartment was, such that the floors had to be taken up and redone. I mean, this was a complete and total gut job.
Exactly.
That was required on this apartment because the tenant prior was a hoarder who had to be evicted, and the claim of the tenant was that the stench that came from the apartment next door was intolerable.
Exactly. And with that, thank you.
Thank you. Mr. DeSimone, we will hear you. 3 minutes.
Thank you, Your Honor. I wanted to reiterate that it's the position of the landlord, obviously, that the DHCR was correct. Pursuant to policy statement 90-10, we were required to show one of the 4 requirements for IAI. In point of fact, we did 2: canceled checks and invoice receipt marked paid. I believe it was Judge Schulman who inquired about whether there was any kind of requirement that you perform the IAI work, the improvement work, at the lowest possible price. And I can represent to the court that I've never found any holding to that effect.
And those canceled checks were contemporaneous, more or less, with the invoices, right?
They were, Your Honor.
They weren't cashed or dated in July when the tenant went to look at the apartment, right?
That's correct, Your Honor.
I think it was July, not August, but in the summertime.
So one other thing, if the tenant had raised certain issues down at the hearing level, you could have addressed them. So for instance, if they claim that you overinflated the price of the work that was done, you would have had the opportunity to at least address it. Maybe you would have been successful, maybe not, but you would have been able to address it.
Correct, Your Honor.
Correct? Yeah, you know.
Okay. Thank you.
Thank you, Your Honor.
Mr. Mitchell, you have 1 minute in rebuttal.
Thank you, Your Honors. Just to make a point, with the original application, that was done by my client pro se. And I asked the court to take deference to that in the sense that he wasn't aware of all the procedural issues in which he had to.
Yeah, you know that's no defense.
I understand,
No,
but
it's not. So we appreciate that you didn't do it, but you know.
But I'm not, but in reference to, under RSC 25299 and DHCR policies, the commissioner can remand something or revoke or modify a decision if there's some irregularities or there's fraud or other aspects or other issues. And I just plead with the court to review that. We've shown that there was a interest between the contractor and the
but only on the par. We can't even look at that. We can't even look at that. You know that.
But you can. It can be. You can do it in the interest under RC 25.
Actually, I don't believe that that's true. But whatever.
Okay. Thank you.
Thank you so much. Have a good night.
Thank you, Your Honor.
Masa Restaurant versus Global Coverage. Mr. Thallander, you have 4 minutes.
Thank you, Your Honor. And I apologize if this should be clarified earlier, but I would like to reserve one of those minutes for rebuttal, if I may.
So you have 3 minutes. Go ahead.
Thank you, and may it please the court. Our 4-count complaint was dismissed on the ground that for one of those counts, negligence, there was no pleading of an act of negligence by respondents. But the complaint does plead such acts, and I would like to highlight 2 of them briefly. The first is respondent's failure to notify two of the insurers carrying policies that respondents were handling for Tetsu, including the insurer carrying Tetsu's property policy. The complaint pleads that respondents assumed the duty to provide notice. They were asked to provide notice. They understood that Tetsu was relying on them to provide notice, and they even indicated they had provided notice.
So, counsel, there's not very much time allotted to you, and my question is, given the fact that there was no compensation here, that there was no contract here with respect to the allegations, could you address the issue of the special relationship and indicate why you believe that the plaintiff was obligated to obtain lead paint coverage? I'm sorry, not the plaintiff, the defendant was required to obtain lead paint coverage. Lead paint coverage was never discussed or contemplated.
That's right, Your Honor. What was discussed was adequate coverage for the construction of Tetsu, and this had been done. This was a part of the relationship that they had for decades between Chef Masa and Global and Share. And time and again, they assumed the duty to research, to determine, and to procure the right kinds of insurance that were necessary. And so under Murphy, Murphy recognizes two prongs where this kind of relationship can give rise to a duty that can be breached and give rise to claims of negligence, or fiduciary duty, or breach of contract, as we claimed here. And one is where there's an interaction regarding a question of coverage with the insurer relying on the expertise of the broker. And the IS court found such an interaction at page 10 of the record, that the pleadings are sufficient to support a claim of the existence of interaction in which Tetsu relied on respondent's expertise as to coverage and other matters that went beyond the mere procurement of insurance. And so if you look at STB, the STB case, there was, in that case, the question was the adequacy of coverage for a demolition. And there was not a long history of relationship. There was just an interaction about the adequacy of the coverage for the demolition. And this court found that pleaded a claim for negligence and breach of contract when the coverage was not sufficient to cover, and even though there was never any discussion about umbrella coverage, that was sufficient to support the claim that there should have been umbrella coverage, or that the broker should have advised for umbrella coverage in those situations. Also, there's another duty here. In addition to the lead paint, so basically the lead paint idea is that the brokers were responsible for deciding what was necessary, and they requested and received all of the relevant contract construction documents, including documents.
Can I ask a question? As I read Judge Sherwood's opinion, and you could correct me if I'm wrong, when talking about the special, whether there was a special relationship to justify a claim, he said, well, maybe yes, maybe no, but that the particular insurance, the lead paint insurance, that really was the obligation of the contractor who came in, and that was why there was no cause of action against this insurance agent here. What do you say to that? I mean, did I understand his reasoning correctly, and what do you say to that?
I agree. I think you're right that Judge Sherwin, he was speculating about the insufficiency of the contractor CNY's own insurance. This complaint is about the sufficiency and the timely notice for Tetsu's insurance. So, well,
the notice issues, the negligent, those issues, are they barred by the statute of limitations?
No, they're not, Your Honor. We have a breach of contract claim that there's no argument there's a statute of limitations issue for. And also the respondents agree, or at least they assert, that the statute of limitations for the negligence claim wouldn't begin to run until there was a denial on the insurance. And with respect to our property claim, that policy was denied in 2018, about a month before this claim was brought, this complaint was brought.
Okay, I've let you go on 2 minutes over You're 3. So we will hear from you again on rebuttal, okay?
Thank you, Your Honor.
Mr. Kronberg, in order to be fair, I will add 2 minutes to your time. You may proceed.
Thank you, Judge. Your Honor, you're correct. There's a statute of limitations problem. The first cause of action, second cause of action, and third are all time bar as measured from the declination. These are liability claims for lead paint, dust to the neighboring buildings. As to the fourth cause of action for breach of contract, there is no contract formation because there's no meeting of the minds. If the plaintiff's complaint, as they say it is, look, we never discussed lead paint coverage. We never thought about lead paint coverage. Therefore, you should have suggested it on your own. How do you then establish the meeting of the minds as to something specific, which is the requirement for contract formation as to lead paint coverage? So I don't even think you need to get to special relationship to support dismissal of the entire complaint. As to special relationship, let's remember that is a primary, and there's a lot of mix up on this. Special relationship is a prima facie element of 2 things: a negligent misrepresentation claim and a breach of fiduciary claim. There is no case that I'm aware of, and my firm is the Murphy v. Kuhn and the Hoffen and Chase Scientific firm, that any court has ever found a fiduciary duty. Interestingly enough, when I saw Judge Scarpula, I'm going to quote from her, if I may, an oral argument in a case called St. George v. National Insurance, index number 653566 of 2014. It's NICEF document 58. It's the oral argument transcript at page 5, line 24. She interrupts me as I'm about to argue against fiduciary duty, and she says, quote, "I know. What is that? There is no fiduciary duty. They are not fiduciaries in this context. They are insurance brokers," close quote. That is a correct statement of New York law. As to
Well, what about the Voss case? I mean, that's an exception. That's the general. Generally, they're not fiduciaries, but then there's the Voss case creates this exception, so to speak, right?
Yes, Your Honor.
I named it right. It's the Voss case, right?
Yes, Voss v. Netherlands. Yes.
Right.
So the Voss and your case STB, the federal court cases of Spinato, Holborn, and Tracy all follow the original seminal case of Murphy, which says if you're going to have a special relationship as to negligent misrep, let's remember Murphy was a negligent misrep case, not a negligence case. It has to be about the thing at issue. And in Voss, it was a business interruption coverage claim because the policyholder had a specific discussion with the broker about getting BI coverage. In Spinato, BI coverage was discussed. In Holborn, they discussed reinsurance, and that's what the lawsuit was about. In Tracy Road, the Northern District rejected a special relationship because credit card fraud coverage, which was the coverage at issue, was not previously discussed. In this case, the complaint is clear. They never ever, and you heard it from counsel just now, never ever discussed, asked for, hinted or suggested lead paint coverage. Now they want the broker to have procured it.
Thank you,
Your Honor.
Okay, Mr. Tholender, you reserved a minute.
Thank you. Quickly, I will say Voss was and many of the other cases the counsel was talking about were prong 2 cases which relied on an interaction. There are a number of prong 3 cases which look to the course of dealing and ask whether the broker was on notice that his expertise was being relied on. And I'll read those out quickly. These are
counsel, but even if that were the case, right? Even if we were to accept that there is this special relationship that your client relied on this broker more than a typical broker, you are suggesting that now brokers should be made to be experts on all construction and have an understanding of all of the potential possibilities via construction. I mean, you would have to have an expertise in that in order to fulfill that kind of duty. Is that what we are requiring now?
No, Your Honor,
broker?
not at all. It's a completely case-by-case analysis. It depends on.
But that's what you're asking of this broker. He's a broker. He's not a construction expert.
It depends what he was being relied on for, what he was holding his services out for. One final quick point is that there is a failure to notify.
Counsel, what you're saying is that because this was a pre-war building, the broker should have realized that lead paint coverage was required. And that, I agree with my colleague, that requires expertise.
Your Honor, that's exactly what they held themselves out as having, and that's why they requested all the documents concerning the construction, including those that indicated there would be testing for these kind of contaminants in this pre-war building.
Thank you so much.
Thank you.
This concludes the session of the Appellate Division, First Department. Good evening and good night.
Stay well, Your Honors.
Be well.
You will. You too.
Thank you.